So thank you for being here, Kate. I mean, I know you're really, really busy. You're always traveling. So I appreciate your time.
Thank you, Arturo. We've known each other more than 10 years.
Yes.
So how could I refuse?
Yes, well, thank you so much. Actually, I was looking in our library of pictures, like when we had you down in Sao Paulo and some other events that you have been with us, and it's amazing. Years go by really, really fast. No?
Yeah, we've been working together a long time.
Yeah. We started this business. The company name, Become American Investor LLC, was actually registered by Greenberg. You were part of that.
Yeah.
Appreciate that. Didn't really know that it was going to be, so many years and that we have grown so much. Thanks for Greenberg.
And congratulations to you.
Yeah, thank you. So, who is Kate and what is Greenberg?
Sure. So my name is Kate Kalmykov, and I co-chair the Global Immigration and Compliance Practice at Greenberg Traurig. Greenberg Traurig is one of the largest law firms in the world. We have 2,700 lawyers all over the world. And our immigration practice is consistently ranked one of the top in the United States. We specialize in doing the whole host of business visas, family visas, and of course, we have a special niche specialty in investment immigration. We have a team of over 150 professionals just working on the immigration applications, but we're uniquely positioned to do EB-5 because we also have corporate securities expertise. We put together projects, we structure deals, we prepare offering documents, we have broker-dealer experts, we have investment advisor experts, we have Investment Company Act experts. So we really give a comprehensive solution to both developers and investors interested in the EB-5 program. And I myself have been practicing in the field of EB-5 for 18 years. And it's been very interesting to watch it evolve. I started doing investor cases for our high net worth clients. And that really morphed into when the 2008 financial crisis occurred to helping regional centers, helping developers get designations, helping them structure deals because there was no financing available for corporate real estate. And so the practice since that time has really grown. We've represented projects from all over the country. We've represented over 8,000 investors successfully in getting their EB-5 base green cards. And we look forward to continuing to work in the field for many, many more years.
Yeah, definitely Greenberg is the one-stop solution for both the developer and also the investor.
Correct,
yes. So is it 8,000 visas? I mean, do you have clients from all over the world?
Yes, so we do a lot of work in South America and Latin America. We have investors from Brazil, from Argentina, from Venezuela, Colombia. We have an office in Mexico City. We have a number of clients from there. We also work with students in the U.S. that are here in F1 status. They like the U.S., they want to work here, they want to stay here, and many times their parents will gift them the funds to enable them to. We have people who have perhaps worked in the U.S. on E-2 visas, and now they want to stay in the U.S. or they want to retire in the U.S., and the EB-5 allows them to do that. And then we have clients from Europe, from the Middle East, and from Asia. So we really, really are familiar with source of funds, which is the critical part of any EB-5 application, and putting it together and understanding what are the specific issues in this country versus this country, what are the issues in preparing financials, getting tax returns, all kinds of things that come up in the preparation. And we have a team of attorneys that speak Portuguese, that speak Spanish, that speak Chinese, that speak Arabic, Russian, you name it, we have it.
That's fantastic, yes. And Kate, our audience, it's really, we're talking to a family which is probably based in South America and is just considering to relocate to the United States. It's either for the family, like relocation, or it's probably their son, their kids that may want to study in United States and then stay in United States. No? I understand, of course, you are, Greenberg, large immigration attorney with a lot of experience, international experience, but countries like South America, there is not even an industry of immigration. Here we have so many visas, but for them, sometimes they don't understand the difference between one and the other. Sometimes they even wonder which type of visa they need for whatever they want to achieve. With so many years in this business, I have heard things like, why will I need a green card? I'll just have to get inside. I already have my tourist visa, which allows me 6 months. So I get in, then go out, and then get inside again, and then I will be able to stay. So if talking to our audience, can we go back to the very basic and think about this family that is considering to send the students overseas, staying here, or a family relocation? Why would they need a green card? What is a green card? How many type of visas does United States has?
Great question, Arturo. So for the family that's overseas that's considering the U.S., it's convenient to use a B1, B2, which is meant to be a tourist visa. So you're supposed to be a temporary visitor entering the United States to come in and see if coming to the U.S. is the right thing for you and your family. But you can't live here on a B1, B2. You get a 6-month entry, but that's it. You can't work on that B1, B2. You can't go to school on that B1, B2. It's really meant for tourism. And we often find that clients don't understand the immigration rules. Maybe they enroll their kids on that B1, B2, and then they have problems getting visas later on. So it's very important to understand the limitations and the rules of that visa. If you want to reside permanently in the U.S., if you want the ability to work in the United States for any employer, if you want to be able to travel freely in and out of the United States without having to go to a consulate and getting a new visa every time, then the green card is the right thing for you because it's permanent residence in the United States. And there's different ways to get to a green card. Obviously, there's the EB-5, where you invest a certain amount of capital into the U.S. in a business that has received a license from the immigration agency to accept funds from foreign investors. That business in turn has to create 10 U.S. jobs. The advantage of the EB-5 is that it allows you to self-sponsor yourself for a green card. So you don't need an employer sponsor, you don't need a family relationship, you sponsor yourself by virtue of your investment, and it also gives you maximum flexibility. So you can come to the U.S. and work, but you don't have to. Or one member of the family can work and the others don't have to. It's up to you. You can live anywhere in the U.S. You're not tied to the location of the investment. Your spouse and your children under 21 get the benefit of the green card. And if you filed the application before the kids turn 21, even if they turn 21 after, they still get the benefit. Plus, you get all the rights accorded to you that a permanent resident gets, right? So you can send your kids to university with in-state tuition. You're not paying those more expensive tuition rates that many foreigners do. There's a whole host of benefits that you get as a green card holder. But if you're uncertain that you want to make the U.S. your permanent residence, or there's something in your home country like work or family commitments that are tying you down, a temporary visa may be a better option. And we call it the alphabet soup of work visas because they're literally an alphabet. We have the H-1B work visa. You need a sponsor. There's a lottery every year. And unless you're from Singapore and Chile, which has an exemption from that lottery, you are, in a lottery of 65,000 available spots. And if you're selected, you can begin working for that company for a maximum of 6 years. There's an L1 visa where if you have a company abroad and you open a U.S. business that's a corporate affiliate, parent, subsidiary branch in the U.S., and you're going to work in the US as a manager or executive, like you did back home, you can qualify for this intracompany L1 transfer visa, and that can be valid for up to 7 years. Certain countries have treaties of friendship with the US, and that qualifies individuals for the E-2 visa. This is a temporary investor visa. You're coming to the US, you're investing in either your own business or you're working for a company that is sponsoring employees subject to that treaty. And the company in the US has to be owned by nationals that are at least 50% the same nationality as you, or listed on your company, on the stock exchange of your country. So the E-2 is very popular, for example, with people from Mexico. They use this treaty a lot. It's not an immigrant visa. You get it for 5 years, but you can keep renewing it indefinitely as long as the business continues. And again, your spouse and your children can come with you and get work authorization. For our superstar clients, our very bright stars, regardless of the field that they're in, whether it's sports or entertainment or business or research, doctors, we can do O1 visas. These are for the people at the very, very top, super talented. But all of the work visas require an employer sponsor. You cannot sponsor yourself as an individual. And this is why the EB-5 makes sense for a lot of people, because they don't have an employer sponsor or they're not prepared to open a business. They rather be a passive investor, but they don't want to tie their immigration success to opening a new business in a foreign country, which can be risky. So those are the most commonly used options for immigration.
Yeah. So would you say that, if I'm an investor or family and I'm considering to a permanent relocation to United States and get the benefits of a citizen, kind of an American citizen, or I will need a permanent residence?
Yes.
Yeah.
So you cannot become a citizen without first being a permanent resident.
Okay.
And if you are applying any other way except marriage to a U.S. citizen, then you must be a permanent resident of the U.S. for 5 years before you're eligible to become a citizen. And by the way, the U.S. allows dual, triple, quadruple citizenship. Okay. So you're allowed to have more than one citizenship as a U.S. citizen. If you're marrying a U.S. citizen and you're doing permanent residency that way, it's a little bit shorter. You have to be a permanent resident for 3 years before you can get the green card.
I see.
Before you can apply for citizenship.
I see. So if I want like a passive way to go to the green card and then convert to citizenship and not have to open any business in the United States and actually do not have to work or being sponsored by another company, probably the EB-5, it could be the best way to do it.
Yes. If you can afford to do the EB-5 visa, it gives you the maximum flexibility. You know, I work with a lot of clients that, for example, are sponsored by their companies. And then something goes wrong or they're not getting the opportunity that they like. They're frustrated with the job and they can't switch because the green card is tied to that employer.
I see.
And for a period of several years, they may be tied to that position. With the EB-5, you're not. You can work, you can not work, you can travel in and out, you can work overseas, you can come back as needed to the U.S. There's no limitations.
I see. So maybe if you take the route of getting a different visa, which is sponsored by a specific employer, then you're really tied to that employer.
Correct.
And all the time you can only work for that employer.
Yes.
What happens if eventually the business relationship ends?
So this is a great question. If you're still on that visa and you haven't gotten permanent residency, your status in the U.S. can terminate unless you find a new employer sponsor. So for example, if I'm an H-1B worker, and maybe I'm laid off because the company isn't doing well, I have 60 days to find a new employer or depart the country.
I see.
Yeah.
So you're really, it's really tied to that employer. And what happens if eventually, you are terminated you need to depart in 60 days, and you don't do that. I mean, is it...
Yeah, and then you can have serious problems, because once you're...
Can I convert to my previous visa? So let's say I'm actually with an F1. I'm an international student, then I went through the H-1B, and I got my H-1B approval, started working for my employer, and business relationship ends, either on my side or their side, and I don't want to depart. Is there a way that I can find a way to stay
So the
here?
answer is going to be different depending on F or H or what your ultimate goal is. If you're an H-1B and you don't find a new employer in 60 days, you have to depart or change status, maybe to a B1, B2 visitor visa tourist. If you're an F1 student and you're working pursuant to your OPT, you also have a 60-day grace period. There are certain students that can extend their status as OPT if they are in a STEM occupation, science, technology, engineering, and math, and their employer is registered as an E-Verify employer. Not easy to find both. Or you can switch to a green card, right? So then we have to figure out, how do you get to the green card? If the employment's ended, it's not going to be employment, perhaps a family relationship. Sometimes we have lucky couples who find love in the United States and they can sponsor each other, but that's not most people. Most people will try to do it through an investment green card because, again, they can sponsor themselves, and already their family, their spouse, their kids are here. They don't want to pull them out of school. They don't want to depart. They want to find a permanent solution. And the EB-5 changed in 2022. The law was revamped to actually make it more advantageous for investors. So if you are now in the US, you can concurrently file your EB-5 petition and your green card. With your green card application, you file for work and travel authorization. This is an amazing development because once you file that green card application, you are in status in the US. So if you're here on an H-1B and you get fired afterwards, you're fine. You're in status. If your business is an E2 business and it's not working out, it's not doing well, you can close it. You're still in status by virtue of filing the EB-5 and the green card concurrently. Plus, your work authorization will be approved, and the work authorization you get through the EB-5 based green card, not tied to an employer. So you can go work for anyone you want or even yourself. It really is flexible.
Exactly. So let's say the EB-5, the new law on the EB-5 with the adjustment of status, it can be the solution for those H-1B visas or different visas that require the employer to convert you into green card, no?
Yes.
So if I'm on H-1B and I have, so this takes about 6 years, right? I mean, you can be on that status for 6 years. And if my employer doesn't want to, even if the business relationship goes well, if they don't want to convert into green card, I will have to stay on H-1B until
You're completely dependent and tied to your employer. Correct. And by the way, if you're on H-1B and your employer hasn't filed for PERM, which is the most common way to sponsor an employee to a green card from an H-1B before your 5th year of age, you are not going to be able to extend that H-1B while the PERM is pending. And the PERM application now takes up to 3 years.
Up to 3 years. So you have about 5 years to be able to turn into a permanent resident.
Yes.
With the exception of doing an EB-5 petition, right, with the concurrent filing for adjustment of status.
Correct. And I also want to say that for students, applying concurrently for an EB-5 and the green card also has been very popular since the new law was introduced, because the students want to work in the U.S. They're here, they want to be part of society, they want to get experience in their fields, And the way they can do it now is when they graduate, they get a year of OPT. But that doesn't suit many of them.
No.
So when we file the green card application, we get them work authorization so they can be a student, go to school, and then go do whatever they want in terms of work. And they really like that. Plus, I think for many students, it's very hard to find sponsorship right now.
Yes.
In a tight economy, in a tight credit market, a lot of times employers do not want to pay money and sponsor students because they're at the beginning of their careers. They don't have a lot of experience.
Correct.
And so they're really making an investment in them, and many aren't willing to. So this gives them a way to remain in the U.S. and work in the U.S. wherever they want to.
Yes, not even just the employer not willing to sponsor an international student, but you have to go through a limited number of H-1 visas available. So even if you want to sponsor, there's no guarantee that you will get the H-1B.
There's 65,000 available, plus an extra 20,000 if you have a U.S. master's degree or higher. Last year, there was about 600,000 applications filed. So you can do the math about how likely you are to get that H-1B.
And it doesn't really depend on you. I mean, I could be from Harvard and having JP Morgan.
It's a completely random lottery. It does not look at who's the best candidate.
I see.
It's just a random computer-generated lottery.
So for international student, I mean, a very good option is actually continue that path from OPT, file a concurrent filing, get the once you do the concurrent filing, can you ask for work permit and travel permit and then stay and work?
Yes. So when we file the green card through the EB-5, we automatically prepare a work and travel application, travel authorization application. And we need to wait for it to be approved, the work authorization, before they begin working, but it's usually routinely approved in 4 to 6 months.
Yes. Okay. That's great. So we cover a lot about students, which is, I think, one of the main prospective or interested investors that we have into relocating to the United States. Huh? But there is also, lately we have seen that, all the parents accompanying the student, it's a family. South America,
Yes.
If the student comes to the United States, sometimes also the parent wants to come along. No? In those cases, we have, of course, the EB-5 program, but I also heard lately some other immigration attorney kind of doing marketing or promoting in South America other type of visas like EB-1, EB-2, international or national interest waiver. What is can you talk a little bit more about
Sure.
this?
So, in immigration, we have 5 employment-based preference categories.
Okay.
So we have EB-1, employment-based first preference, and it's broken down into 3 subcategories. The EB-1A is for people of extraordinary ability. So these are, again, the people that are superstars at the top of their field. They have to show that they meet 3 out of 10 criteria, and the criteria include things like significant contributions to their field of endeavor, having a leading and critical role in an organization or company in the field of endeavor, publications, presentations, materials about the alien, whether it's press interviews, whether it's citation histories, honors and awards, peer review, high salary. So you have to work to meet this criteria, and it can't just be one thing meeting each criteria. You have to show what they call international acclaim, national and international acclaim. So you have to have a record of achievements over time, and it has to be sustained. It has to be very good. The great thing about the EB-1A is that it can be in any field. You can be an amazing soccer player for the Olympic team from wherever you're from, or you could be a hedge fund manager and also be an EB-1A. And also you can have an employer sponsor, or you can self-sponsor yourself. But you have to show your intention to work in the US in that field. And you really have to be able to meet this high level. So not everybody can do it, right? It's, I get sometimes people straight out of school coming to me, I want to do an EB-1A.
Yeah.
You're not going to qualify.
Yeah.
They're very strict. They don't count any experience during university study. They don't count awards in the company where you've worked. They really want them to be prestigious, hard to get, and you have to show the criteria to do that.
I see.
EB-1B applies to outstanding researchers. So this is something very specific for people who have tenure at universities or are working for large companies like pharmaceuticals. I don't think you probably deal with a lot of those.
No.
And EB-1C is equivalent to the L-1A visa. So it's a multinational manager executive who's been working for at least 1 year in the preceding 3 years for a company overseas. And now they're being transferred to the US to also be a multinational manager executive. And the two companies have to have a corporate relationship. So this is really for our high-level C-suite executives, people who manage functions at their companies. And they actually do have to be multinational companies. Sole proprietorships don't work. And you have to show that when you're permanently deciding to stay in the US, that the overseas company continues to operate. So it really is meant for larger companies, companies with significant revenue, companies where we can show an organizational hierarchy, because if you're an executive or a manager, we have to show that you're managing employees and that they're not what the immigration agency calls our first-line supervisors, that they're professional employees. The EB-1C has to be company-sponsored. You cannot self-sponsor. And you asked about the national interest waiver. The national interest waiver is in what we call the EB-2 category. So now we're in the second preference category. And here we have to show that the person has also a claim in their field, but it's a little bit of a lesser standard than extraordinary ability. Because while we want to see what the person has done to make sure that they're talented, that they're exceptional ability, we have to also show that their work is in the national interest of the United States. And why is it in the national interest of the United States? So for example, I do this frequently for researchers. Maybe they're working on some unique cancer vaccine. Maybe they're researching stuff related to agricultural methods of farming to make it more efficient. Maybe they're researching global warming. I do this for doctors a lot. But it's also quite broad and quite diverse. I mean, I'll be honest with you, I did a while back a series of national interest waivers for sports players. I did a whole host of opera singers where we showed that their coming to the United States was in our cultural interest for our country. So these are, for us lawyers, fun, unique visas, but they're not for everybody because you really have to meet very stringent criteria.
So let's say if I'm a successful entrepreneur in my country and I was able to do a large company and become rich and have several employees, would you say that?
I would say the lawyer answer, which is it depends.
It depends.
Yes, I would need more information. I would tell you Greenberg will give you a free consultation because you're coming from BAI, and that we would evaluate if it makes sense for you.
Correct. Okay, and what happens, let's say you have, you're now working with Greenberg, but let's say this investor has been advised to do some kind of any of this petition. Would probably the audience that we're talking to, it would probably be more, it's either in EB-1C or national waiver EB-2. And then, they file the case and it's denied. What happens then? I mean,
it's of course the basis of the denial. If it's not denied for an inadmissibility issue, let's say a crime in their history or an arrest, but they just didn't qualify, it's okay. They're not prejudiced. They're not going to be banned from coming to the U.S. They can apply for Some of them will try to do that category again. Sometimes they'll build their resume until they have a little bit more accomplishments to demonstrate. Or they will try to apply for the green card in a different category. And by the way, the U.S. immigration law allows you to file multiple immigrant petitions.
Correct.
So you can have an extraordinary ability petition filed at the same time as a national interest waiver, and maybe you don't quite meet the criteria of the extraordinary ability, but you get approved for national interest waiver. It's fine. It's the same path to a green card. It's the same green card at the end of the day.
Correct. They convert to green card.
Yes.
And how long does it take, let's say, if I start working for the EB-1C or national interest waiver, which is probably more national interest waiver, till I get the green card?
Overall, about 1.5 to 2 years, but you can expedite that first part of the process so that you know whether you're going to be approved or not. So that I-140 immigrant petition, whether it's an EB-1A, whether it's a I-140 national interest waiver, you can pay to have it expedited and have a decision in 2 weeks. And then it's just a matter of the government processing your green card application. At that point, if you don't have something inadmissible in your history, you just have to wait for the government processing times. And that's about 1.5 years right now. Sometimes it comes faster.
And what is a PERM?
PERM is an application through the Department of Labor system made by a company on behalf of an employee to sponsor them for a green card. So we have PERM in 2 categories, EB-2, so second preference, and EB-3. EB-3 is for people who have at least a bachelor's degree or skills equivalent to a bachelor's degree. EB-2 is people who have a master's degree or higher. So to do the PERM, the employer has to apply to the Department of Labor for something that we call a prevailing wage, because they have to show for this position in this geographic area with this required experience, we want to pay this much. And then the government will tell you if that meets the prevailing wage, which is the minimum that the government says you have to pay to get the green card or not. If it does, that prevailing wage gets certified, and then the employer moves on to the second step. And this may sound a little strange, a little counterintuitive, but they actually probably already have the employee working for them, but they have to advertise 5 different ways for the position. Because the Department of Labor wants to make sure that we're not displacing U.S. workers with foreigners. So they require the employer to undergo recruitment for that position. And if there is a applicant that is minimally qualified, they can't proceed with the PERM. Now, why am I saying this is counterintuitive? Maybe I have the best, the smartest, the most successful person working for me. If I find someone that has the minimum qualifications for the position, I cannot sponsor my superstar foreign worker. That sounds very strange, but again, it's all about protecting U.S. workers in this process. Why is a national interest waiver a waiver? It's a waiver of the PERM requirement.
I see.
But this is the way that most people get the green card through employer sponsorship. So the employer conducts recruitment. If they don't find U.S. workers, then they file the PERM with the Department of Labor. The Department of Labor takes about 6 to 8 months to either certify or deny it. If they certify it, if they say, yes, we believe you can't find somebody, you can move on to steps 2 and 3 of the process. In step 2, you show that your foreign worker has the qualifications you were recruiting for. So experience letters to demonstrate it, their educational documents you'll need to present. And then you as the employer have to show that you have the ability to pay the prevailing wage. So you have to be prepared to submit financials to be able to show that. That's not a big deal for big companies, but for smaller companies it sometimes is, particularly if they're relatively new and they're startups and maybe they're not yet cash flow positive and they're still operating in the red. And then the third step, if the I-140 is approved, is the actual green card application. So that's a PERM process, and the PERM process will take about at least right now 2.5 years to 3 years.
So that's actually the way that usually H-1B.
Yes, so most H-1Bs get sponsored for perm. But I do want to remind you that we have a limited amount of green cards given every year.
Oh.
It's 140,000 green cards in all of the 5 preference categories.
Oh, I see.
EB1 gets 10,000, EB5 gets 10,000, EB2 and EB3 get 40,000, and it's not enough. So we have people that have been waiting for perm for many, 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 many years. They have an approved perm, but they can't proceed to this third step, the green card process, until their number becomes current on what we call the visa bulletin.
I see.
And so, for example, if you're Indian and you're EB2, the wait time is 50 to 60 years for a green card, which
50.
is absolutely insane. If you're EB3 and you're from Mexico, you also have an extremely long wait for the green card because so many people have applied and there's only a certain amount of visas that you can get every year. So you stand in a line in a queue until your number is current.
Wow. And so that's why the waiver, it's the waiver.
The national interest waiver
goes out.
Waives this perm requirement. The EB1A, the EB1C, they waive this requirement, and of course the EB5 is another way around it.
Exactly. So before we get into EB5 with more specific, and now talking to the Mexicans in particular, I remember there's one visa or there's called TN.
Yes. So the TN is pursuant to the NAFTA treaty, and it's a visa that's available to Mexicans and Canadians pursuant to NAFTA. It's not available to everybody. It's available if your occupation and the position that you're being sponsored for, you still need an employer sponsor, is on the approved NAFTA list of occupations. So if it's not, then you cannot use the TN category. The other thing you need to know about the TN is your spouse and your children can come in, but your spouse doesn't get automatic work authorization like they would with an L or an E. And it's a non-immigrant visa. So you can renew it, you can process at the border, you can renew it in the US, but it's not a path to a green card. It's not permanent residency. It is temporary. It can be approved for 3 years and you can renew it.
I think that once the audience is listened to this, number of options or number of visa, each one, it looks like it's dedicated to one specific situation or profile of the investor. I think
everybody's situation is different.
Correct.
Sometimes people, a lot of Mexicans come in on E2 visas working for big Mexican companies with operations in the U.S.
Yes.
So it's hard to say that the TN is the one for them. It's not. Or, a lot of Mexicans are entrepreneurial, for example. They like L's and they like E2s.
Correct.
We may get people from other countries in South America, and maybe some of them have a dual passport. I know a lot of people in South America that I meet have an Italian passport, have a Spanish passport, and it gives them the ability to apply for an E2, and it works for them because maybe they're looking to open a business and invest in the U.S.
Correct. Is the E2 ever converting into green card?
No.
And the kids below 21, let's say I move in with the E2 and I was able to provide my kids below 21 with the E2 visa. What happens when they are out of 21?
They age out. With the E, with the L, with the TN, with the O, with the H, you hit 21 and you're on your own.
They have to find their own way.
So maybe some of them sometimes switch to a student visa and the family is in different statuses. But unless you're doing a green card process, they're going to be on their own.
Somehow we all get to the same point that, if you have the investment capabilities, you want to relocate to the United States, you want to be passive in the United States, and you want to be kind of certain and not really depend on employers or other circumstances. Looks like the EB5 maybe.
I think when we're thinking about maximum flexibility, the EB-5 is the way to go.
Correct.
Because not everybody is extraordinary, or even if they are, maybe they don't want to work in their field, right? Maybe they want to retire. Maybe they want to take care of their kids. Maybe they want to explore different options. The EB-5 gives them that opportunity.
Exactly. So let's talk about EB-5. I mean, first, we know that Greenberg was able to get involved in passing the new law last year, and we may say that we still have EB-5 program in part thanks to Greenberg.
We're very proud of our work on the new legislation. We were also involved in litigation related to changing the investment amount when it was improperly introduced, in striking down an improper interpretation of the new law by USCIS. So we have really been in the trenches working on shaping the EB-5 program. And I think we got a great result.
Yes, you did. I mean, we're all in the same industry. I think I always thought that EB-5, it's a win-win for the investor and for the country and for the developer. No?
Absolutely.
Because at the end, it creates
it's foreign
jobs
direct investment into the U.S.
Correct.
It's a job creator into the U.S. and it's at no cost to the U.S. taxpayer.
Correct. Yes. So, what is it that you need to qualify as an EB-5 investor? Let's say we now get to the point that somebody's watching this video and say, well, this is for me. In addition to the capital, what would you say are the next steps?
So, in order to apply, you have to obviously have the money to invest, but you also have to be able to show the source of the investment funds. Where did you make the money? Was it income? Was it a sale of real estate? A sale of stock? Did you get money in a divorce? Did you win the lottery? Was it a gift? Where did you get the money? Document it. And then show the movement of the money from the time it was received by you all the way through until investment. Bank transfers, did it go through different investment accounts? Show that movement, because the U.S. wants to know that the money coming into the U.S. is from a lawful source. And if you can do those two things, then you've satisfied your requirements in an application to qualify for EB-5. Then it's also very important to determine what project you are going to invest in. You should be confident that it's going to create 10 jobs per investor, because that's the requirement the project needs to meet in order for the EB-5 to be successful. And to do that, there's a whole host of things that you should look at. I can't speak to financial due diligence, but on the immigration side, does that company have EB-5 experience? Does the regional center have EB-5 experience? Have they done other projects? Have they been successful? Did they get all approvals? Have they had any denials? How long have they been doing this? Those are the things that a successful EB-5 investor wants to look at. And then, of course, you work with your attorney to put together a filing package. And once that's submitted, you also can, if you're here in the U.S., submit for the concurrent green card. But if you're processing overseas, then we will work with you to process through your local U.S. embassy or consulate in order to get the immigrant visa, which will enable you to enter the U.S. as a permanent resident.
Exactly. So basically on the EB-5, you're doing a petition, and then once the petition is approved, you have to go through a consular, probably a consular step to get the green card in the passport.
When you're applying for the EB-5, you're showing information from the business that is raising money. So it's obviously prospective. It's in the future.
Yes.
So we have to, at the end of the 2-year period after you get your initial green card, submit a third application. That's called an I-829, petition to remove conditions. And in that application, we actually have to show how the investor doesn't have to show anything. Mm-hmm. The company needs to show how did they spend the money in order to show that the jobs are created. And if they can show that they did that, then you get the permanent green card, then you can go on to citizenship and all of the full benefits of any individual living in the United States.
And when we're talking about a due diligence on the project, not from the financial point of view, but let's say I'm just an investor and I'm considering to invest into a project, we say that it needs to create 10 jobs per investor. How can I do that due diligence? I mean, when do we need to, the project needs to create those jobs? Is it immediately? Is it how long do
It's within 2.5 years of EB-5 approval. So they have time to create the jobs. It's not an unreasonable requirement.
So it's the approval on the I-526.
Correct.
So meaning if the I-526 takes about 2 years or 3 years and then 2 more years. So
they have about 4 or 5 years to create the jobs, which is good. When you're investing into a large project or a commercial real estate project, they need time to do that. And it needs to be feasible for them.
And in 10 jobs per investor, is it payrolls? Is it direct jobs?
It can be, but most of them are not. So if we're looking at regional center projects, what are regional centers? They're businesses that have gotten a license from the U.S. Immigration Agency to accept funds from foreign investors. And the benefit, the beauty of becoming a regional center is that you don't have to look at payroll. You don't have to look at your direct jobs on site. You get to get the benefit of what we call indirect employment creation. What is indirect employment creation? If I'm building a hotel, for example, and I spend $100 million in construction costs, I get to count the costs of construction, my hard costs, my soft costs. I get to count the multiplier effect of that hotel being built in the area. So how many jobs are created once people come to the hotels, operations jobs? How many jobs are created once they go out shopping, once they go to the theater or to a concert or to eat at a restaurant? All of those are multiplier effects, and that's why so many investors choose the Regional Center EB-5 program, more than 95%.
Correct.
Because there's always a surplus of jobs in those projects. And when you're asking about due diligence factors in selecting a project, you want to choose a project where you don't just get 10 jobs per investor, but there's also a cushion in case maybe you construct a little bit less. You're still covered.
Correct. Yes. Going back a little bit on the source of fund. No, I mean, we have, we're talking about 800,000 plus expenses. And even though we're talking to pre-qualified investors, no, sometimes they have that money invested somewhere else, no? So will that, like loans, third-party loans, family money, will that count for the investment? And can they get a loan through their companies, through themselves, through the family, raise the capital and then invest it for one petition?
They can. So you don't have to earn the money yourself. You can take a loan, and it can be a secured loan or it could be an unsecured loan.
Okay.
There's certain documentation that you need to present that differs between the two, but they are permitted. Certainly gifts are permitted. When we talk about college students doing EB-5, obviously they don't have $800,000 yet lying around. So of course that usually is a gift from family. And gifts, by the way, do not have to be between family members. They can be unrelated persons. I've had people that gift the money to their nanny because she's been with them for 30 years and they can't imagine living without her. Perhaps we have people that are friends that are gifting each other money. Or, we have people that sometimes will be gay spouses where their jurisdiction, their home jurisdiction doesn't recognize their marriage, so they have to gift it to each other so that they can do the EB-5.
And when you talk about gifting from one member to the other, you base the source of fund on the one receiving the money and doing the filing, or is actually...
We have to show where the giftor made the money to make the gift. Yeah. So you do have to speak to them and make sure they're ready to provide all of the evidence we already discussed in terms of financials, bank statements, tax returns, etc. But many times that's not an issue.
Okay, there are some countries in South America that have restrictions on exchange rates. For example, Argentina is not that simple just to convert the money in Argentina into US dollars. No? Do you have experience with those situations? How hard is it? What is the way USCIS look at these things? Do you understand it?
Yeah, so the USCIS is very focused on this, but it doesn't mean that you can't submit a successful application. You just have to figure out a way to explain it and explain how you were able to exchange the money. So we deal with many countries that have currency restrictions, and almost all of them have exceptions to the currency restrictions. If, for example, I have a relative that's already in the US, it doesn't apply to me in many places. I can transfer it. Or many countries allow friends and family to transfer to get to the whole sum that you need. Some allow you to use a licensed money exchanger, right? Other times the bank has exceptions to allow a certain amount of outbound investment. So there's a whole host of ways that we can show it, and we will work with the investor. We will sit with them on the phone and go over the documentation before they make the transfer, so that we know that we're submitting a viable case to the USCIS and one that is going to be successful.
I see. And there's also, let's say we can call it tax efficient situations where the investor, which is usually entrepreneur and owner of a company, instead of moving the money, it's more in the company than in their self. Can they move the money through themselves as a gift or as a loan and then do the investment?
They can. It's just a question of papering it properly.
Correct.
So that it's submitted to the USCIS in the format that they require.
There could be a loan between the company and the investor.
Correct. And we do those quite often.
Exactly. Okay, so let's move a little bit more on the new regulation, the new law, and the change of the adjustment of status. No?
Yes.
We understand that to do an adjustment of status, you need to be inside the United States, and you need to have, of course, a legal visa inside the United States. No? So it's easy to understand that you may be in F1 visa or H1B or L1 or any other type of visa would like to convert, get the path to get the green card. What happens if I'm considering, because nothing is fast, not even in EB-5, and I may have a perspective to, let's say, relocate to the United States in less than a year or something. Can I do an EB-5 from my country overseas and then get inside as a tourist and then kind of do a adjustment status?
Yeah, so you can submit an EB-5, you can enter the US on a tourist visa, and after a certain period of time you can file for a green card from here if you don't want to consular process overseas. That is permitted.
That is permitted. Okay. So what is missing? Do you know some kind of
I think statistics about who applies the most.
Yeah. So we cover unsecured loans. We talk about Argentina. It's really tough.
This is a good question for Bracha.
Yeah. We're going to see Bracha here. Yeah, so really good questions. Yeah, that's the NC and all that stuff, right?
Yeah.
Do you want to talk about anything else, Kate? You think it's,
I think it's good. If you want me to, I can go over this, but this seems more up her alley.
Okay.
Choosing the right project and the different entities. Do you want me to talk about that, or do you want to do that?
Okay. So yeah, let's go through that.
Okay. So.
If you wanna close or something, I can talk to the people.
No, I don't think so, because we're interview style.
Yeah, exactly.
Arturo, I made you cry.
No.
The interview's ending.
No. So, when we are those, we probably, if we talk to our audience and they are families overseas, sometimes they don't really understand the whole industry of immigration, the different kind of visas. They have to rely on the advice of a good immigration attorney. And of course, people like us, we have a lot of time doing this. We're more project side and we're not immigration attorneys. But how, and we tell them, it's EB-5, it's a passive way, it's a straightforward. If you want to get the green card, it could be the Ferrari style to get to United States, no? But then we say it's really important to work with the right team, the right immigration attorney, with the right product, do your own due diligence on the project. What specifically would you say, based on your experience, they have to look at?
This is, I think, the $1 million question or the $800,000 question. So a couple of different things, right? I think if you want the green card, you have to make sure that your immigration attorney is reviewing the project and make sure it meets the EB-5 requirements. Mm-hmm. That attorney should have experience doing EB-5. It shouldn't be their first case doing EB-5. You don't want to be the experiment. You want to make sure that they have a track record. And if there are issues, that they can identify them. And then you go to the regional center and you have them answer them. Ask them to show you information. And then I think it's very important to look at the regional center. How long have they been doing EB-5? How long have they been approved? What's their record of approvals? What's their record of denials? Have their projects gotten requests for evidence? Have they gotten notices of intent to deny by the immigration agency? And then I look at the project. Who's the developer? What's the capital stack? If it's all EB-5, run away.
Correct.
Make sure that there's other financing in the project. How much skin in the game does the developer have?
Correct.
What is the exit option? How are you going to get out of there? How are you going to get your money back? What is their plan for financing if they don't raise all of the EB-5 money? Do they have alternative sources of capital? How many projects have they done similar to this? How long have they been working as a developer? Unfortunately, we saw at the beginning of EB-5 many scams, many fraudulent deals where if the investors had asked the right questions, had asked for evidence, they probably would have never invested. Now the EB-5 industry, it's more sophisticated. People understand more, they have friends that have done it, and they know what questions to ask. You can go site visit projects. You can go see the location. You can go see the other projects that the developer has done to give you a sense of, are they successful or not? Can they deliver what they're promising to deliver or not? Do they have the government permits in place? What's the timeline for construction? How do I know that's going to happen? Explain it to me. I think the investor who really takes the time to diligence, to ask questions, and now after COVID, you don't even have to come to the US to do it. They'll take you on Zoom and show you everything that you want, live, one-on-one. But I think that's very important.
And Kate, when we talk about the different players in one particular investment, EB-5 investment, so you have the immigration attorney, which is really representing the investor for the I-526 petition. Then you have the developer, which is really going to create the jobs. Then you have what we call the MCE or the EB-5 fund. And then you have the regional center. The tendency today is that there is a separation there between regional centers and the EB-5 fund. And actually, in our case, we're raising capital for ourselves. We are on the developer side and we are on the fund side. As I said before, it's kind of a boutique. We're only raising money for our own projects. No? What's the role of the regional center in cases like that?
So the regional,
it's
a great question. The role of the regional center is to really report to the USCIS. So you have to make sure that you're getting the information from the project as the regional center. How much of the money that was deployed to you from the fund was used? Show me the requisitions. Show me how it was used. If it wasn't used properly, they need to see that, and they need to work with the developer to address those issues. The regional center needs to make sure the developer is staying on their timeline, and if they're not, they need to figure out why. The regional center submits annual reports.
Correct.
The regional center agrees to be audited by the USCIS, and the USCIS for each project agrees to do a site visit, which they coordinate through the regional center.
Correct.
The regional center is also the one supplying and gathering this information and giving it to the investors. So they are
Correct.
giving them documentation about the projects. They supply them with the K-1 tax forms every year related to their distributions from the fund. They are generally the general partner of the NCE of the fund, and they are making decisions on behalf of the partnership or the limited liability company, in case there's any problems as well.
Correct. And would you say that, there are different ways to invest in one particular project, specifically as a loan or as an equity, going from the fund to the investor, to the developer entity?
Correct.
So we can go to the market offering an investment which is based on equity or another investment which is based on loan. I think the difference is really not just on the return on the investment, but more about how safe it is to recover the capital back and all that. No? We like both. We particularly do a lot of equity investments. But what is your feedback on that?
So I don't think I can speak to which one is
Correct.
safer or not, because I've seen good deals and bad deals on both. With the loan model, what you have is your special purpose vehicle, your new commercial enterprise, your fund. The EB-5 investors are limited partners or limited liability members in this fund. The fund aggregates capital, and then it makes a loan to the JCE, which is the job creating entity. That's the project. That's the actual project. And that loan can be mezzanine debt, it could be a senior loan, it could be second tier, it could be second tier mezz, flexible. In an equity model, it's a little bit different because the NCE, the new commercial enterprise, and the JCE are one. So it's the same entity. The investors invest money into the actual project, and they become a certain class of shareholders in that project. I think a lot of questions that I see from investors is always, how do I exit? How do I get repaid? And the answer is going to be different depending
Correct.
on the project, but also whether you're doing a loan or an equity model.
Correct. Yes, in our case, when we approach to our investors, as I said before, the main interest to get the green card, but they're also really interested to get the capital back. They evaluate the project from not on the return on the investment, but more on the how risk is to exit and return the capital.